Good morning, everyone. Welcome to the African Summit of the Global Toolbox on Corporate Climate Litigation project. Today, we have the pleasure to be in Nairobi with colleagues from different parts of Africa and particularly from Kenya. And my co-chair today here is Dr. Mondewino, that is going to introduce us to the first panel. Let's start let's go immediately to start with our first keynote speaker that is going to talk about climate change litigation and justiciability. So we have a great honor and pleasure to have him with us, Justice Preston. I think that everybody knows Brian Preston. Justice Preston is the Chief Judge of the Land and Environmental Court of New South Wales. Is part of our project since the beginning. Is part of the core group of the project Global Perspectives on Corporate Climate and Tactics. Brian Preston as prior to being appointed in November 2005 was a senior counsel practicing primarily in New South Wales in environmental planning, administrative and property law, and is a big experience lecturing in postgraduate environmental law for over 30 years. And he is also the author of Australia's first book on environmental litigation, and more than 100 articles, book chapters, and review on environmental law, criminal law, and administrative law. Justice Preston is an official member of the Judicial Commission of New South Wales. He is a fellow of the Australian Academy of Law, fellow of the Royal Society of New South Wales, and honorary fellow of the Environment Institute of the Australia and New Zealand. And the list is very long, and we just want to say that we are really glad that Brian could join us online today from Sydney. So without further ado, I leave the floor for our first keynote with the Honorable Justice Preston. Thank you very much for being with us, Brian.
Well, thank you. It's a great pleasure. I have many fond memories of being across in Kenya. I did training of many of the judges of the High Court and Court of Appeal, not only in Kenya, but also in Tanzania and Uganda in early 2006. And so I thoroughly enjoyed my time there. So it's wonderful that I'm able to present, at least remotely, although it would be wonderful also if I was able to be there in person. So I'm going to talk about justiciability issues in climate change litigation. And so this will include not only litigation against corporations, which is of course the one of the focuses of the legal toolbox, but also against governments, often governments who are setting the regulatory climate for corporate activity. So my lecture will be in two main parts. The first, I'll open up and just remind ourselves of what we're talking about when we refer to justiciability. And the second is then I'm going to look at the trends in justiciability of climate litigation. And I'm going to group that in three areas of law: private law, administrative law, and constitutional and human rights law. So let's start with what is justiciability. So a legal claim, whether we call it a cause of action or any other legal suit, it has to be justiciable in order to be adjudicated by the courts. So what is justiciability? Well, one definition is that it involves the quality of being capable of being considered legally and of being determined by the application of legal principles and techniques by the courts. And justiciability is a threshold question. If a legal claim is not justiciable, then the court has no jurisdiction to hear and determine the suit, and therefore it would need to be dismissed at the outset. So how have the courts defined justiciability? I'm going to refer to some definitions: the United Kingdom, United States, and Australia. So starting with the United Kingdom. So the House of Lords, in one case, described the converse, that is, non-justiciability, as being not of discretion but inherent in the very nature of the judicial process. Or a controversy is non-justiciable if there are no judicial or manageable standards by which to judge the case. Remember what I said before, going back to this one, it's the quality of being capable of being considered legally and determined by the application of legal principles and techniques. That's what we're looking for. And that's what, in this case, in the House of Lords, they said there are no judicial and manageable standards, therefore it would be non-justiciable. What about the United States? So in Baker and Carr, justiciability was said to involve the determination of whether the duty asserted, so in the legal claim, can be judicially identified and its breach determined judicially, and whether the protection for the right asserted, that's the remedy, can be judicially moulded. So non-justiciability of a political question is primarily a function of the separation of powers. So what we can see here also is this search for a legal criterion upon which the claim can be adjudicated and remedied. If there is such a one, it'll be justiciable. If it's not, it'll be non-justiciable. In Australia, so Australia takes a rather broad view of what is justiciable, but in this case, in the federal court, they said there's no general principle that decisions which are made in the public interest or which are politically controversial are immune from judicial review. Now, you may have heard that the American doctrine of justiciability is often referred to as the political questions doctrine. And that is an unfortunate description because it seems to imply that if there are political questions involved, then it's non-justiciable. But in fact, that is not the test. It's whether it falls within the judiciary's province to be able to adjudicate a claim using legal standards. And so this case in the federal court in Australia is picking up on that point. It's saying just because a case involves the public interest or is politically controversial doesn't make it immune from judicial review. So determination of the question whether a particular decision is justiciable involves consideration of all the surrounding circumstances, and in particular, it involves finding that there is a legal criterion by which the claim can be adjudicated. Now, I'll just give you an example where a case in Australia was held to be non-justiciable. So this was where the cabinet, the federal cabinet of the government of Australia, decided to exercise its prerogative power to nominate an area for listing under the World Heritage Convention. Now, that was challenged by a mining company whose interests would be adversely affected, it feared, by the nomination and perhaps acceptance as a World Heritage area. And the question was that exercise of the prerogative power to nominate the area for World Heritage listing justiciable? And Justice Wilcox adopted this formulation of justiciability. The first question was, does the claim affect some person other than the decision maker, either by altering rights or obligations to that person which are enforceable by or against them in private law? Note here, a legal criterion is available, or by depriving that person of some benefit or advantage which would otherwise reasonably be expected to continue. And again, reasonably is reasonably in law. That is, there is an expectation that benefit or advantage would reasonably be expected to continue in law. And the second one is the exercise of the particular prerogative power susceptible of review and on what grounds? And again, susceptible of review on legal criteria. And so again, we can see the question of whether it's justiciable or not turns on this availability of a legal criterion to adjudicate the claim. So how had the courts approached justiciability? So you would have seen from the United States decision that they refer to the separation of powers doctrine, and that is this division between the three arms of government, the judiciary, the executive, and the legislature. And so the executive and the legislature exercise so-called political functions, whilst the judicial or quasi-judicial functions are exercised by the judiciary. And the concept or doctrine of justiciability is designed to enforce this concept of the separation of powers. Unfortunately, those functions of the three branches of government do overlap. So the result is the doctrine of separation of powers could be described as a good servant but a bad master. So different courts have approached the issue of justiciability different, and that can be seen to be influenced not only by the court's constitution and jurisdiction, the legal system generally, but also the legal culture in the country. And of course, the particular claim, because one is trying to determine whether that claim is justiciable. But the ambit of what has been previously been considered as being non-justiciable is certainly changing. And so what we're seeing with climate change litigation is that the courts are becoming more prepared to identify a claim as being justiciable rather than non-justiciable, although we do see some pushback by courts and finding that certain claims are non-justiciable. So why is justiciability important for climate change litigation? Well, firstly, it is because of the very nature or subject matter of climate change litigation. It concerns problems that are complex, polycentric, interdisciplinary, transjurisdictional, and multiscalar. And the classic example, of course, is the climate change as a global problem. And the proving climate change is causing harm in law involves challenges to conventional notions of causation in law. It is also important because of the fact that we've got a global problem, but that engages law at different levels: international law, national law, subnational law. And the problem that climate change litigation is attempting to resolve has strong socio-political and economic elements. It also has raised the so-called floodgate argument. If this claim were to be allowed to be litigated, then the floodgates will open and the courts will be inundated by other people bringing claims like the subject claim. And there's that fear that opening those floodgates and allowing claims to be determined by courts will infringe the separation of powers doctrine. So with that introduction, let me come now to see how justiciability has arisen. And as I said, I'm going to look at three domestic law streams where justiciability issues have arisen in climate litigation. And they will be private law, administrative law, constitutional and human rights law. Starting with private law, we can see private law litigation, climate litigation, in the torts of nuisance and negligence, but also in public trust. Now, the tortious actions have historically been most prevalent in the United States, but more recently, we've seen tortious actions brought in the Netherlands, New Zealand, Australia, and Canada. Now, those cases, tortious cases in the United States, have many times been dismissed on grounds of non-justiciability. And so I referred earlier to the Baker and Carr case, and we can see that that case enumerates 6 factors which may indicate the existence of a non-justiciable political question. The first is that there is a textually demonstrable commitment of the issue to a branch of government other than the judiciary. So it's gone to the legislature or the executive. The second is a lack of judicially discoverable and manageable standard for resolving the issue. Again, what I said, a legal criterion. There isn't a legal criterion. The third, the impossibility of deciding the issue without first making a policy determination of a kind clearly of a non-judicial discretion. Now, this is a tricky one because, as I said, in the Australian case, often legal claims do raise policy determinations. But the key to understanding this third one is that adverb first, without first making the policy determination. So it's not that you can't make a policy determination in the adjudication, because courts do that all the time, but it's that you can't get to that adjudication without first making that policy determination. That's the criterion. The fourth one is the impossibility of the judiciary to undertake independent resolution without expressing a lack of respect for the other branches of government. Again, a tricky one, because if it is properly within the province of the judiciary to determine the matter, and they determine it adversely to the legislature or the executive, does that mean you're expressing a lack of respect? I think not. The fifth one is a political decision has already been made. Now, again, that may be the very subject of the challenge. So to say that a political decision has been made about the matter may be what is the subject of the judicial review claim. The fifth one is a potential for multiple pronouncements by various branches on the one question. So therefore there is sort of coterminous decision making. So those factors are used in United States regularly, but they are problematic and they are not regularly used in countries like Australia. But to give you where they have been applied, here's one case, Connecticut and American Electric Power. So here, a number of US states sued the 5 highest emitting electric power companies in the US. The district court at first instance held the threshold question of whether the complaints not raised non-justiciable political questions, and it determined that they did, and therefore dismissed it on the grounds of non-justiciability. And the court relied on that third Baker and Carr factor. So just going back to that, that's the impossibility of deciding the issue without first making a policy determination of a kind clearly of a non-judicial discretion. And they said that that is what had happened. And so they said these cases presenting these political questions about climate change are consigned to the political branches, executive and the legislature, not the judiciary. That was appealed to the Court of Appeals, and the finding was overturned, and saying that the action in tort didn't present any of those 6 non-justiciability factors in Baker and Carr. And the Court of Appeals said that the political question doctrine should be cautiously invoked. So unless one of those formulations, that's the 6 I've said, the Baker and Carr, are inextricable from the case at bar, there should be no dismissal for non-justiciability. And regarding that third factor, which the district court relied upon, they said that where the remedy sought by the plaintiffs is not provided for in statute, the plaintiffs may seek their remedies under federal common law. They need not await an initial policy determination in order to proceed on this federal common law of nuisance claim. Now, subsequently, the Supreme Court, on the final appeal, did reverse the Court of Appeals decision, but importantly, not on the grounds of justiciability. Rather, they did so on the basis that the statute, the Clean Air Act, displaced the federal common law so as to preclude that common law public nuisance claim. So in the case of Kivalina, there was again a suit in nuisance against oil, power and coal companies. Exxon contended that the claims were non-justiciable, and the district court did uphold that. Now, there wasn't an appeal. Well, it was an appeal on that, but the Court of Appeals applied the Supreme Court's decision in the Connecticut American Electric Power case that the Clean Air Act displaced the federal common law of nuisance, and hence found it unnecessary to determine whether the claim was justiciable. Now going to the Netherlands, the Agenda case. So we well know that case. It was sued by Agenda in not only nuisance, but also for a breach of the European Convention on Human Rights. There were justiciability questions raised, but at each instance, the courts, so the District Court of The Hague, the Court of Appeal of The Hague, and the Supreme Court of the Netherlands all dismissed the government's claims that the Agenda's claims were non-justiciable. So the District Court said it didn't interfere with the system of separation of powers because the claim concerns legal protection and requires a judicial review. So the essence of it is that there was one claim under the Dutch Civil Code in negligence, and a second claim under the European European Convention on Human Rights. Both of those claims were capable of being resolved by the application of known legal criteria. Therefore, they were justiciable. In Smith and Fonterra, a New Zealand case, which has worked its way up to the Supreme Court, they brought claims in tort, public nuisance, negligence, and a breach of a novel duty of care against the 7 largest New Zealand carbon emitting companies. And it was, at first instance, the public nuisance and negligence claims were dismissed by the High Court as not being justiciable, although they didn't at that stage strike out the novel duty of care claim. However, there was an appeal to the Court of Appeal, and the Court of Appeal not only affirmed the District Court's decision to strike out the first 2 causes of action, but also struck out the novel duty of care claim. And they, the Court of Appeal, considered that it was non-justiciable, and for 4 reasons. One, the claim was brought against a small subset of those responsible for the alleged harm, and the defendants would face an indeterminate liability. Second, the scope of activity was not in the domain of tort law. Third, there was no remedy which was available to the court which could meaningfully address the harm complained of. And fourth, bringing proceedings against some emitters is an inherently inefficient and ad hoc way of addressing climate change, which would open the floodgates to indefinite litigation. So you can see a number of those Baker and Carr 6 factors coming through there, but also this fear that there will be an infringement of the separation of powers and the opening of floodgates. Now that went up to the Supreme Court, and in the last couple of months, the Supreme Court overturned the Court of Appeal and obviously the District Court, and allowed the matter to proceed to trial on all 3 causes of action. And the Supreme Court said that both the claims of negligence and the novel duty of care should proceed on the basis that the public nuisance claim did not meet the threshold for being summarily dismissed. They determined that that public nuisance claim was not bound to fail and shouldn't be struck out. And because they're not striking out the primary cause of action in public nuisance, there was nothing to be gained by striking out the other claims of negligence and the novel duty of care. And so we can see the 4 questions that the Supreme Court of New Zealand addressed were actionable public rights pleaded? Was independent illegality required? Was a special damage rule measure required? And was there a sufficient connection between the pleaded harm and respondents' activities? Now, they are rather particular questions, but what the court was doing here, it was essentially finding, were these claims capable of being resolved by legal criteria? And was there a remedy that was able to be determined, again, according to legal criteria? And having answered that, yes, they said the matter should proceed. What about in Australia, where we had some litigation? It was a novel case about a duty of care against the Federal Minister of the Environment under our relevant federal environmental law. And the question was, did the Minister owe a duty of care to the children, because it was a youth plaintiff's case, to decide whether or not to approve an extension to a coal mine which would cause or contribute to climate change. Now, at first instance, the court held that the duty of care should be imposed and rejected the justiciability issues, and saying there was no reason why imposing a duty of care would cut across a policy decision of the minister. Think of that Baker and Carr question about, is this a policy question that has been engaged with by the political branches of government? On appeal, the full court overturned the primary judge's decision and held that his common law duty of care should be imposed. And so, amongst other reasons, the court held that it was not appropriate to impose a duty of care because it raised policy considerations about the proper response to climate change, which made it unsuitable for judicial determination. And the Chief Justice, or the then Chief Justice, particularly seized upon this point about the unsuitability of the judicial branch to judge the legitimacy of the duty of care. And I won't go through the particular passages that I've quoted on the slide, but you can see that, but you see it's picking up these concerns that these are matters of core policy that are best left to the political branches of government, namely the executive and the legislature. So now moving to public trust law, and as we know, this is stemming from Roman law. It's come into the common law. It's concerned with communal natural resources that are unable to be individually owned. These are things such as the air, fresh water, and the sea. And the concept is that those communal natural resources are vested in the state as the public trustee of a public trust, and that is to be exercised for the benefit of the people. So climate change litigation, particularly in the United States, has invoked the public trust doctrine, saying that the atmosphere is part of the public trust. It's a communal natural resource that is incapable of individual appropriation. And the government, as trustee of the public trust, of this atmospheric public trust, has certain duties to manage it appropriately for the benefit of the people, including ensuring a stable climate. And so those have been the actions. Now, a number of those have been those actions have been challenged on the basis of justiciability. And so I've given some examples there in Alaska, in New Mexico, and in Oregon, where the courts have dismissed those cases on the basis of being non-justiciable. Going to Canada, this was a case where they were challenging Canada's greenhouse gas emissions and alleging that was in violation of their rights under the Canadian Charter of Rights and Freedoms, as well as the public trust doctrine. So the federal court found that the claims under the Charter were not justiciable, however, held that the claims under the public trust doctrine were justiciable. And they said that the public trust doctrine of common law as unwritten constitutional principle is a legal question. And the question of whether the government's actions infringed that legal principle was a legal question, and hence it was justiciable. Going to some of these cases where they found that it was justiciable. So one is in Montana. So this is a case of Held, one of the plaintiffs' names, and there was an application that the energy policy of the Montana state violated the public trust doctrine and certain constitutional provisions. And the Montana District Court upheld those claims as saying that they were in violation of the public trust doctrine. Now, that's the state has filed an appeal in relation to that matter, but importantly, they were held to be justiciable. So that leaves my civil law. Now let's come to administrative law. Now, we've seen many cases around the world. This is probably the most common area in which there has been climate change litigation, that is administrative law. And here we're concerned with the legality or validity of administrative decisions. And there are various categories, but we can see them grouped in illegality, irrationality, and procedural impropriety. Now, mostly those cases have the grounds upon which the justiciability issue arises is that they say these are challenging the separation of powers doctrines by the judiciary trying to step in to review political decisions of the executive and the legislature means they're crossing the line and going into a province into which they've got no jurisdiction. So one case was one up in Canada. Now, this is an old case. Under there was a bill which became an act forced against the Canadian government, against Stephen Harper, who was the Premier at the time, and that was to implement the Kyoto Protocol. So Canada's Kyoto Protocol obligations. So the government, because it didn't want this act, didn't comply with it. And so the Friends of the Earth brought the action to try and compel the government to comply with this act, and that is its Kyoto Protocol obligations. Ultimately, the federal court said, well, the act did not impose a justiciable duty upon the minister, and therefore would not or dismiss the proceedings. So you can see there the quote, the decision-making process under the Act is policy-laden consideration, not the proper subject matter for judicial review. There are no objective legal criteria which can be applied, which would allow a court to decide it. So see that what I've been saying a number of times, the courts are looking for, are there some legal criteria that can be used to determine the matter? This is another New Zealand case, an earlier one, brought by actually a law student, Sarah Thompson. Here, it was a challenge to New Zealand's 2030 and 2050 NDCs under the Paris Agreement. And the court held that it was justiciable. In other words, rejected the minister's claim that it was non-justiciable. And it said that the court could review the government's decision to set the NDC under the relevant legislation. And although it didn't intervene because there had been by that time a change of government and the incoming government had promised to set a more ambitious NDC. So my last category is then constitutional and human rights law. So we know that both constitutions and statutes can enshrine certain rights. Obviously, a right to life would be one, but also many constitutions, including the Kenyan constitution, a right to a healthy environment. And so these rights have been used now for climate litigation. So because these rights are enshrined in constitutional statutes, and they're afforded to all persons universally, the issue of justiciability has been less of a barrier, because quintessentially these raise legal questions for determination, which can be determined using legal criteria. Those criteria are the very rights themselves in the Constitution. So we haven't seen as many cases there. But one was where it did raise with the Juliana litigation, and that's because they sought to invade not only the public trust doctrine, and we've seen how the courts deal with that, but also the due process clause under the Constitution. And there was questions about what right they were trying to imply. So at first instance, the district court said that none of the 6 factors in Baker and Carr were inextricable from the merits of the case, and thus the political question doctrine didn't apply as a barrier to the plaintiff's claim. And so it said there's no need for the court to set outside the core role of the judiciary to decide this case, because firstly, there was a claim that there was a violation of the constitutional rights, including the due process clause. And secondly, it was said that there was a violation of the public trust doctrine, which had been incorporated as part of the common law. Now, so there was no justiciability issue. In first instance, there have been multiple appeals, and ultimately the case has been dismissed, not on justiciability grounds, but on standing grounds. And that is what I've set out there. I want to go through that. So back to the Netherlands, I said that there was not only a claim in negligence under the Dutch Civil Code, but also under the European Convention of Human Rights. And so there was no, the claim that it was unjusticiable or non-justiciable was rejected because the courts were determining the claim under the European Convention on Human Rights, and that was a justiciable claim. Again, we can see that the Supreme Court held that it was justiciable, saying, and I'm the last quote on the last bit, whether the state is complying with its duty under Articles 2 and 8 of the European Convention on Human Rights to observe due diligence and pursue good government is a task of the judiciary. That is, it's squarely within the province of the judiciary and hence justiciable. So the Supreme Court rejected the various claims of the state of Netherlands, the apostrophe is in the wrong place there, saying as to the first ground of non-justiciability, the Supreme Court held, if the state has a legal duty to do something, in this case under Articles 2 and 8 of the Convention, it's appropriate for it to be ordered by the courts to comply with the duty. And this does not involve the courts intervening in the political decision-making process that was involved in the creation of legislation. So the courts are not entering into the field of political decision-making at all. And the district court's remedy, that is an order that the government stop breaching its duty under Articles 2 and 8 of the Convention, didn't amount to an order to take specific legislative measures, but rather it left the state free to choose what measure was appropriate in order to achieve the particular target. In relation to the second ground of justiciability, non-justiciability raised by the government, the Supreme Court held that the climate change policy that the state had pursued since 2011 is clearly not in accordance with the goals of the Paris Agreement or the state's duty under Articles 2 and 8 of the Convention. So the Court of Appeal was allowed to rule that the state is in any case obliged to achieve the proper reduction of 25%. So again, they're saying that because there is a legal criteria, both in the Paris Agreement and the European Convention, then the court was able to fashion a remedy which was using legal criteria. Coming to Australia about human rights law, there's a recent case in Queensland by the Queensland Land Court, and there the objectors, who are again a youth group, said that the Human Rights Act, the State Human Rights Act, applied and regulated the government decision as to whether or not to approve the coal mine because of the adverse effects on the claimants and young people by reason of the mine's contribution to climate change. And there was the mining company moved to strike out that claim of the youth's plaintiffs on the basis that the court didn't have jurisdiction to consider those objections. The Land Court rejected that and said that it did have jurisdiction to consider those objections based on the Human Rights Act because that was the law. The law required the decision maker, including the court, to consider whether or not approving the coal mine would infringe those specified human rights. So that brings me to the end. What I'm saying, hopefully, as you've understood, is that justiciability is a multifaceted threshold question. There are many factors that have to be taken into account. But it does require consideration of all of the surrounding circumstances of the particular claim. Now, because of the complexities and the political nature of climate litigation, the fact that it's pushing boundaries, the fact that it's dealing with a global problem, the fact that it's dealing with politics and values, has meant that there are justiciability issues raised. But courts have been increasingly amenable to determining that these climate litigation claims are within their jurisdiction and appropriate for the judiciary to adjudicate. Thank you.
Yeah, thank you very much, Justice Preston, for that quite illuminating discussion on justiciability. I think as lawyers, really, if you do not have a justiciable claim, then you do not have any claim worth carrying to court. And I believe that has been quite eye-opening to our online audience and the in-person attendance. And I think at this stage, I will now open the floor for any questions, both I think online and in person. So for the online participants, just type your question on the chat and we will take it up. And for the in-person attendance, I think just feel free. We'll give you the microphone.
If you have any question for Justice Preston, otherwise we can free him. I think it's quite late also in Sydney. And thank you again, Brian. It was really a fantastic overview. And as I told you, Brian Preston, Justice Preston has been a part of our project since the beginning. And we decided to start this African Summit with this keynote. And as you know, we will finish with a closed session for the judiciary at the end of the second day, where we're going to have a sort of judicial training, taking stock of our work with the African group, so from Kenya and from Nigeria. And so if there are no questions, I think that we can thank you very much again, dear Brian, and see you very soon. So I would like to, yes, please, thank you. So I would like to take advantage of this just to introduce my colleague, Dr. Mondi Owino, that I didn't have the chance of doing before. So Dr. Owino is the Kenya rapporteur in our project Global Perspective in Corporate Crime Legal Tactics. He is a senior lecturer at the School of Law at the Jomo Kenyatta University of Agriculture and Technology in Nairobi. And you may don't know, but Dr. Owino is also a brilliant practitioner and leads the Environment, Energy and Climate Change Law Department at Acorn Law Advocates, always here in Nairobi. Here with us, there is also, you will meet him later, Dr. Uzuadza Etemir, our Nigerian National Rapporteur, who is also an associate professor of law at the University of Port Harcourt, but we will see him later. So let me start with a short introduction on this project. So I will start with a short outline with an introduction of what we are doing at BICL, then just a few words on this field, that is corporate crime litigation, its scientific basis, why this is interesting, because in a way it's also a quite increasing phenomenon. And then I will show you a few details about this project that took us since last year in September 2022. So, as an introduction, just a couple of words about BICL, the British Institute of International and Comparative Law, where I'm the research leader in environmental climate change law. This institute was created in 1958 by the merger of the Society of Comparative Legislation, so a society from the 19th centuries, and the Grotius Societies that was established at the beginning of the 20th centuries. And interestingly, the initial signatories established an independent research body unaffiliated to any universities, which is committed to the understanding, development, and practical application of international comparative law. So just to say, the founders of BICL were a group of individuals with a wide range of legal interests and experience, including, probably you know them, some of the most illustrious legal minds of their time, like Baron Denning and Hersch Lauterbach. And as you probably know, because BICL in the last more than 70 years has been a prominent research institute in different areas. As you can see here on the slide, we are really focusing on a range of areas between international and comparative law and the rule of law. So these are the key areas that constitute the main focus of our research events and activities, and also teaching, training. So you see there is the Center for International Law, the Center for Comparative Law, and the Bingham Center for the Rule of Law. And as you can see, we cover really a broad range of issues: business human rights, migration, trade investment, competition, product liability, cultural heritage, many others. And this just to say that we started this project in a place where we have this broad perspective, and where, in a way, we try to do this cross-sectoral research. And I wanted to highlight the independent role and the independent side of BICL. So in the latest year, we work extensively in relation to climate change, in particular to climate change litigation. So as you can see here, before going into the details, next slide please, of our project, let me just provide some pointers on this field that we have been exploring in the last years. The corporate aspect of climate litigation. First, I wanted to start with a caveat on the terminology we use. So, you know that private companies are, without any doubt, a critical part of the super big problem that is climate change. You know, time is running out. There is no central authority to tackle it. And those that are seeking to end the problem are also the ones that are causing that. However, the companies, in our opinion, are also important. They might provide the means to mitigate this problem, especially in the current needed energy, ecological just transition context. And that's why we are talking about corporate climate litigation, and we didn't try to talk about climate litigation against corporation, because we would like to avoid this contraposition between the NGOs, the citizens, the local communities on one side, even the governments, and on the other side, the companies. And I think this would consider the corporation as a fundamental actors in the fight against climate change. That's why I wanted to precise this at the beginning. On the slide, you see there are some of our work, a couple of edited volumes that we published in the last couple of years, climate change litigation and global perspectives. So always this idea that we have a equal to work internationally and comparatively. And the second one that was published in January, that is about climate change litigation in Europe, with of course contribution to global climate litigation and some other reports and work that we have done in the areas. Unfortunately, when I'm talking about this choice of terminology, it's not just our will to avoid this contraposition. At least, as I said, we are a research institute, but also because we are currently witnessing cases where the companies are invoking the courts to contrast the claimants. This is what we call the SLAP lawsuits, so the strategic lawsuits against public participation. And here we have generally the fossil fuel giants that allege damages for defamation against the NGOs in attempt to counter their legal campaigns. And in a way, this is a corporate tactics. We studied this in our project, corporate tactics, also to suppress criticism by hindering public protest, by draining economic resources by the defendant. This is something that we have seen in many parts of the world. There is a case that was decided just a couple of months ago in April in France. That was this case against Greenpeace brought by the fossil fuel giant Total. Of course, Greenpeace was sued over a report that they published that was claiming that the company massively underestimated its 2019 greenhouse gas emission. And of course, Total didn't agree with that and asked the court, the civil court in France, to order Greenpeace France to delete the report and all the related publications. And of course, they asked for a fine of 2,000 euros per day. And of course, the total summons that they said was came up in April, dismiss this claim. And so that was the Paris Judicial Court. So this was to have an idea. The scientific basis for corporate climate litigation is also quite interesting because in a way this shows a part of this complex picture of climate litigation involving private companies. Particularly, we are talking about the carbon majors because, these are the greenhouse gas major emitters. Mostly we are talking about fossil fuel and cement companies, which were already identified, as you can see on the slide, in 2014 by Richard Healy, that is also a member of our core group, together with Brian Preston and other illustrious personalities. And the Climate Accountability Institute that Rick Healy is directing showed through an assessment of the historical contribution of these companies to greenhouse gas emission, to the global greenhouse gas emission. And it said that basically these companies that were like around 90 entities, they contribute to 63% of the carbon dioxide and methane emitted between the half of the 19th century to 2010. That was in 2014, this report. This is data brought, as I said, by the Climate Accountability Institute. This is something that, in a way, is also very interesting for this kind of cases. Climate scientists can run simple climate models, not as simple, to calculate, among other things, that amount of the global average surface temperature and sea level rise is linked to the emission from a carbon producer, which is absolutely interesting. And this is really a new field of science, relatively new, I was saying, that is growing rapidly with advances in what we call the attribution science. And this is something that we see a little bit all over the world. I put on the slide Oxford, the University of Columbia. There is the Union of Concerned Scientists that works so much with in the US with the different claimants and plaintiffs. And just the last two references, Grasso and Hidi, so Rick Hidi with Marco Grasso from Italy, published last year, new research that quantify and highlight that the world's top fossil fuel companies owe at least $209 billion in annual climate reparation to compensate communities most damaged by their activities. So in a way we see, I mean, of course, it is not something that probably is going to be used to court right now, but to show us a little bit, you know, how much this is worth. And no, in reality, there is already some cases that are using Rikides in the climate accountability research, like, for example, the Luya versus RWE case that is brought by the Peruvian farmer Luya against the giant company, RWE energy company in Germany. So it's a transnational case, and they really using this calculation made by Rikides group. I just finished with Norway. This is a book that is called Merchants of Doubt, and Naomi Leskens, that is an history of science professor at Harvard University, is also part of our core group with her colleague Eric Conway, shows the similarity between the tobacco litigation, the tobacco disinformation, let's say, campaign, and the fossil fuel industry's current effort to show confusion, to say, in fact, we are not sure about that. You know, we are always talking about the precautionary principle, we're talking about climate change. So in a way, we see these similarities. This is a very interesting book that I recommend. And if you don't have time, there is also a very interesting documentary that was made out of this book. So just in case, next slide, please. And so we just finishing this overview on corporate crime litigation about the increasing number of corporate crime litigation cases. We've seen in the latest year really a surge of cases in climate litigation, not only against fossil fuel firms, as I said, but also against other polluting industries, with many cases challenging corporate inaction on the climate crisis, and also attempt to spread misinformation, as I was saying before. And companies in a way are increasingly recognizing this kind of litigation as a risk. As you can see on the slide, the sub-in-center databases, which are in this moment the more exhaustive database that we have, Columbia University, they currently take into account more than 200 cases worldwide. And this is without counting the cases in the US, where this kind of litigation in a way started, where we found some of the first very cases brought against the corporations. I put in the slide some of them. We are not going through that. Village of Kivalina against ExxonMobil in 2012, but also cases brought by states against utilities companies, like the one that Justice Preston mentioned, American Electric Power Association versus Connecticut, and against automotive companies such as California versus General Motors. This, as we see, is a trend that is going a little bit everywhere in the world, in Germany, in France, in very different countries around the world. And in the last decades, in a way, the target for climate litigation extended beyond these carbon-intensive industries. And so in addition to the continuing trend in cases concerning a company's contribution to climate change through the greenhouse gas emissions, we see other types of claims against businesses. We are going to see in these 2 days across the various sectors that began to emerge. And this includes the claims concerning director duties. This is going to be always bigger, I think, even though I put in the slide the case that was unsuccessful in the UK, Keynote versus Shell, but also we have cases concerning companies' obligation to adequately disclose the financial risk of exposure to climate change brought about by their business activities. This was a case, for example, in Australia, Macleay versus Rest, and was finished that end up in a settlement, but very interesting case against this pension fund. Anyway, this is really also showing another areas that could be another kind of actor that could be really critical, and all of this in a way on this all these very heterogeneous landscape of litigation involving companies can create a ripple effect between countries. In reality, this is really what we try to understand. We try to understand in our work with Omondi, with Usuazo, with all the great experts from Africa and from the other part of the world. So we try to track the development of this new kind of litigation. So you see here is the first page of our project, the global perspective on corporate criminal legal tactics. You see there is a QR code. You can scan the QR code embedded in this slide to access the project's web page. So if you want with your telephone, as I said, this is a project we started all together in September 2022. It's a comparative study that analyzes the possibilities, the possible avenues, the hurdles, and the prospect in this kind of litigation. And we try to take stock of the legal experiences and tools in the different countries around the world to discuss innovative possibilities. So our project is really taking stock of what's there, but we would like also, we try to also have some ideas for the future. And this was something that was presented in London, and the fruit of this journey is the global toolbox on corporate criminal litigation that I'm showing right now, that is an open access collaborative platform. So just to show you the collective goals, please next slide, that are clear: to map corporate criminal litigation globally, to catalog the pivotal cases. We have already, as I said, more than 500 cases around the world, but many more if we consider also the US. The idea of foster strategic thought, as I said, which will be also helpful in litigation planning in the different parts of the world. And also, in a way, this is, of course, probably the main goal is to motivate corporate change through raising awareness of the litigation risk for the companies. This is the project working group. As you already met Justice Preston, that is part of our core group. We put together, as you heard, some of the most internationally renowned experts from the different parts of the world. Then, of course, we have the 70 national rapporteurs, like Dr. Ovino and Dr. Etemir. And then we have, we try to work on the 17 countries that at that moment had already some corporate crime litigation or beginning of corporate crime litigation at least. And around them, with their help, we build up this international expert group, which you will meet some of these experts today. It's made of experts from academia, from legal practice, scientists, judges, and many other experts that help our rapporteurs to have the best available information and to discuss the possibilities in this field. So you see, this is the core group. You see there is Brian Preston, Keynote that we mentioned, Dr. Emmanuel Shabuya, who is the Minister of Justice now in Rwanda, and is also part of our group. We have experts from China, from America, from Europe, from Asia and Africa, from every part of the world. And next slide, this is the international expert group. You just see the different countries all over the 5 continents. And I would like to show you, as part of this project, please next slide, we created the corporate crime litigation platform, which is composed by 3 parts. So there is the CCL resources, so the corporate crime litigation resources, which is a collaborative repository of literature and references in the field. Then you see beneath there is the corporate crime litigation database that is, let's say, a work in progress. It's going to be an AI-powered database, which will be developed in the next months in collaboration with Climate Policy Radar, and a comparative laboratory that is this CCI toolbox that allows us to delve into the challenging of corporate crime litigation. So next slide. Yeah, so just to show you, this is the CCI resources. Next one, and yeah, here you see. And this is the toolbox. You will see in the middle we have the platform that we created, but then you have, of course, the conference and summits like this. We have the recording, and we have all the materials related to this. We have the national reports that have been published in February, March. And next slide. These are the national reports from our Kenya and Nigeria expert groups. And you see there, that is the page with the other 15 national reports for this year. So just a glance to the global toolbox, and then I leave the floor for the first panel. So please, next slide. This is the global toolbox as it looks like, of course, a cut and paste into two different parts. You see there the screenshot. As you can see, it is something that encompasses the work on 17 countries, the comparative analysis on 17 countries, and is funded on 3 axes. So we have the causes of action, and in the next slide, we have also the causes of action. We have really all the different kind of causes of action: human rights, environmental and climate change statutory provision. We have tort law. We have corporate law. You will see, you can browse, and you will see it's open access. And then we have the second. No, before. The second axis is procedure and evidence, and the third is remedies. In each of these, you can click and you will see there is many more. Like, for example, consider the issues. There is issues like justiciability that Justice Preston discussed earlier. There is jurisdiction. We are talking about, of course, anything that relates to all the hurdles to jurisdiction, justiciability, group litigation, apportionment, all the, let's say, procedural issues that we can find in the different legal systems. And in a way, you can see on the right, we have a little bit the schematic structure that we decided to use, for example, for the causes of action. And you see we go through each of these causes of action, analyzing, of course, the most important precedents, also the legal models that we can find in different legal system. We try to find the core elements that we can find in each of the causes of action in the different legal systems. And of course, we try to analyze hurdles and challenges and the prospects that you've seen. And you will find at the end also some sort of, you will find the country summaries. So it's going to be also easier to browse on that. So this is really a testament to our global collaboration. That's why I call like this a collaborative journey. The legal systems are varied, but our challenges are shared. Just let's finish with the last slide, which show you that we are halfway through our dissemination plan with the Kenya conference, the African Summit. And we will continue in a couple of weeks with the Philippine conference and the Asian Summit, and through the different continents and legal system. We try to take advantage of this moment to create collaboration with you, with the experts in the different legal fields in the different continents, to try have a discussion to test what we have done and to try to improve, because this is just the beginning of our journey. So thank you very much for your attention. In the last slide, there is my email, but of course, you can join me also on the video website. Thank you again, and I leave the floor to my colleague, Dr. Wim.
Yeah, thank you so much, Dr. Alonia, for that very elaborate explanation on the global toolbox and what we're doing. I'm sure climate change is on everybody's lips,